everybody, welcome to another impactful episode of Let's Clear It Out with Anita. It's good to see you once again, and I'm really grateful for all your views, your likes and your comments, even those that comment via my WhatsApp. Thank you so much. Thank you so much. So this is another episode of Let's Clear It Out with Anita, and we'll be treating acceptance in contract law. Alright, so as we start the video, I hope you learn one or two things from this video. Alright, let's get the learning started. Acceptance is the second basic requirement of a valid contract. When an offer has been made, it materializes into a contract once it's been accepted by the other party. By definition, an acceptance is an absolute consent or assent to the terms of a contract. An offer must be accepted in accordance with its precise terms for it to become an agreement. The key point here is that a valid acceptance must be clear, absolute, and without conditions. Secondly, the acceptance must be done in time or done within a reasonable time. In the case of Crushed Rock Industries Limited versus Uber, the Court of Appeal explained that acceptance to an offer must be plain, unequivocal, unconditional, and without any form of variance to the offer. BCC PLC versus Sky Inspection Nigeria Limited, acceptance was defined as an express or implied indication made by the offeree while the offer remains open and in a manner requested in the offer of the offeree's willingness to be bound unconditionally to a contract with the offeror on the terms stated in the offer. It means that an acceptance can be in an express form or in an implied form, right? Now, the offeree has to make an express acceptance or an implied acceptance while the offer remains open. Remember, we said that acceptance must be done timely or within a reasonable time, right? And his acceptance must be unconditional. Furthermore, what are the requirements of a valid acceptance? Number one, acceptance must correspond with the offer. This means that it must agree with all the terms of the offer. If it tends to qualify or vary the offer, it becomes an ineffective acceptance and then called a counter offer. We should remember our key points that acceptance must be plain, unequivocal, unqualified, unconditional, and without variance of any sort to the offer made or without addition or subtraction to the terms of the offer. What are the effects of a counter offer? It leads to a rejection to the original offer, and the original offeree cannot subsequently accept it. Secondly, it amounts to a fresh offer to the original offeror who may accept or reject. A viable instance to a counter offer could be seen in a buying and selling situation. So when a seller offers to sell his goods for 15 naira and the buyer, instead of buying it for 15 naira, negotiated to 40 naira. That 40 naira negotiation has voided the 15 naira initial offer. Alright, that means that the buyer refused to buy it at 15 naira. Now, the 40 naira negotiation, which is the buyer's intent, becomes a fresh offer. Alright, now the buyer changes to becoming an offeree who should accept, but an offeror who is now proposing a new offer to the seller, and the seller can either accept to sell it as 40 naira or decide to reject it. First, to constitute a valid acceptance in law, the offeree must accept the terms of the offer absolutely without variance or qualification. That means the buyer should buy the goods at 15 naira without any form of negotiation or bargain with the seller. Conditional acceptance. In law, any acceptance that is subject to a condition is invalid and unbinding. A conditional acceptance means agreeing to an offer only if certain conditions are met. Once there is a conditional acceptance, it creates no legal and enforceable obligation except where the conditions stipulated has been carried out or fulfilled. A cross offer. A cross offer occurs when two parties send identical offers to each other at the same time without knowing about the other's offer. Cross offer does not amount to acceptance. An instance to a cross offer could be said to where Mr. A intends to sell his house. It would not amount to acceptance if he writes to Mr. B that he's selling it for 5 million and Mr. B, without knowing this, writes to Mr. A that he wants to buy the house for 5 million. Where this is done, it amounts to a cross offer and not acceptance. Thus, this could also be said simply that where the buyer and the seller simultaneously makes the same offer. Alright, when a buyer and the seller simultaneously makes the same offer, that offer becomes a cross offer and not an acceptance. Moving forward, we have acceptance in ignorance of offer, where a party is oblivious of an offer but acts in a way that coincides with the terms of an existing offer. Such act does not constitute acceptance. In essence, one cannot accept that which he knows nothing of. Communication of acceptance. The general principle of acceptance is that it is ineffective until it has been communicated to the offeror. Now, communication could be done in writing, in words, or by conduct. A mere intention to accept an offer is no acceptance. First, the buyer must communicate that he wants to accept the offer which the offeror is giving to him. Alright, he cannot say that he had the intention to accept it. He must actually communicate either in writing, either by words or by his conduct. Moving forward, we have acceptance by post. This is an acceptance made by emails or letters. Once the offeree properly posts his acceptance to the offer, such acceptance is valid even if it gets delayed or gets lost by accident in the post. The rule was laid down in the case of Adam versus Lindsay. In this case, defendants made an offer by post to the plaintiffs for the sale of goods. The post didn't get to the defendant in time because the plaintiffs wrongly addressed the letter. Upon receiving the letter, the defendants replied their acceptance on the same day they received the letter. The letter of acceptance was received on the 9th of September, whereas the plaintiff expected it on the 7th of September. Since the letter wasn't received in time, the plaintiff sold the wood to a third party. The court held that irrespective of the delay, a valid contract was created the moment the defendant posted their letter of acceptance. Exceptions to the rule of Adam versus Lindsay. A. If the offeror indicates that the letter of acceptance must reach him first, then until the post is received by the offeror, the contract hasn't been created. Secondly, if the letter of acceptance was posted wrongly or posted to the wrong address, the rule would not apply. Thirdly, the rule will also not apply where the court sees that the application of the rule in Adam versus Lindsay would lead to manifest injustice or absurdity. Moving forward, termination of offer. Number 1 is revocation. The offeror can withdraw his offer at any time before it is accepted. However, if the offer has been accepted, the offeror cannot withdraw his offer anymore. Also, if the offer will last for a specific period of time, it can be withdrawn before the expiration of the time. But if acceptance was done or made before the expiration of the offer, the offeror cannot still withdraw his offer because acceptance has been made already. Secondly, we have rejection. Where the offeree rejects the offer, it automatically terminates the offer. He cannot change his mind and accept the offer later on. Once the rejection has been done, it must be communicated for it to be effective. Lastly, we have lapse of time. Where the offeror imposes a time limit for acceptance and the offer is not accepted within that time, it kills and terminates the offer. When there is a time limit, it becomes an essential term of the contract. Thus, any acceptance outside the time frame amounts to an alteration of the term of the offer.
Remember, we said that a valid acceptance is done when there is no form of alteration or variance.
Thank you so much for sticking with us up till now. I'm sure that you've learned one or two things today. So do well to hit the subscribe button, like and comment, and I'll see you in my next video. Bye.